All right. Good evening, everyone. My name is Adam Carson. I am a principal planner with the Rockland County Planning Department. I'm also the executive director of the Rockland Municipal Planning Federation. Welcome to session 2 of our certification series, the update of case law. The Rockland Municipal Planning Federation is a nonprofit organization that was formed over 34 years ago. One of our primary functions is to provide and promote educational programs for land use board members so that they can make more informed decisions about the land use applications that come before them. The certification program actually started back in 1993 when the towns and villages in Rockland and the county itself agreed that their ZBA and planning board members should be required to take a specific training course created by the Federation. Board members in Rockland County must complete sessions 1, 2, and 3 to be certified, and retake session 2 every other year to be recertified. All 3 sessions are held in the spring, and the second session is held in the fall, which is happening tonight. This requirement predates the New York State 4-hour training mandate, but fortunately for you, this session will apply towards that requirement as well. I do have a few housekeeping announcements before we get started. Session 2 is unique in the various programs offered by the Federation, and that attorneys can earn continuing legal education credits. The New York State CLE Board has several requirements that I'm obligated to follow, the most significant of which is the use of attendance verification code words. I will provide code words throughout the session. These code words are only relevant to attorneys seeking CLE credit. If you are not an attorney, you do not need to worry about them. I recommend attorneys write them down. I will be giving the first one very shortly. Once I give them, I will not repeat them later in the session, and I would ask everyone else to do the same. Additionally, I'm obligated to send a course evaluation and an attorney affirmation form by email after the session to every attendee. Again, if you are not an attorney seeking CLE credit, you do not have to return them. If you are an attorney and want CLE credit, you will have to complete the attorney affirmation form and return that to me. Next, the Federation maintains attendance records that we regularly share with the towns and villages within Rockland County. So local board members usually do not need a certificate of attendance. But if you are on a board outside of Rockland and need a certificate, please email me a request that includes your name, municipality, and board. I will share my email again towards the end of the session. Please know that due to the volume of requests, you will probably not hear from me for probably about a week, actually. And lastly, all your microphones are muted. If you have a question, please type it into the Q&A function. I'll be monitoring the Q&A and I'll relay your questions to Attorney Adana periodically during the session. Please limit your questions to the cases being discussed or general areas of law. Christy is not in a position to give advice or opinions on specific projects or active legal actions in your community. As promised, I will now give the first attendance verification code word, and that is LEAP, as in 2024 will be a leap year. All right. Tonight's session looks at some of the latest developments in land use law, and we are very fortunate to have with us tonight Attorney Christy Tomadana. Christy is a partner at Silverberg Zelantis LLC, where she works on litigation and appeals, as well as land use applications. She advises municipal boards, including those in the towns of Haverstraw and Ossining and Village of Tarrytown. She also counsels parties appearing before municipal land use boards. In addition, she has worked on a number of Article 78 proceedings. She further assists the firm's clients in drafting commercial contracts, including leases, contracts of sale, construction contracts, advising on employment law issues, and commercial litigation. Christy regularly lectures on zoning and land use topics and has been acknowledged every year since 2018 as in the New York Metro Super Lawyers as a rising star in the area of land use and zoning law. Prior to joining Silverberg Zelantis LLC, Christy was employed by civil litigation law firms and worked on cases from commencement of lawsuit through trial and appeal. Christy has worked for a variety of clients, including large corporate entities, not-for-profit corporations, and individuals. Her prior experience also includes insurance defense, tort, and maritime law. Christy received her BA with majors in economics and history from Swarthmore College and graduated magna cum laude from St. John's University of Law. She is admitted to practice in New York, New Jersey, the Federal District Court of New Jersey, and the Federal Southern District of New York. And with that, I will turn things over to Christy. Welcome.
Thanks, Adam, and thank you everyone for joining us this evening. I was really happy to be back in person in May, but I know that for a lot of people it's more convenient to do it by Zoom. So I'm happy that we're able to kind of split the difference so that we can accommodate everyone. And thank you all for spending your precious fifth Wednesday of the month with us. We couldn't pass up that opportunity. So what I'm going to do, Adam, which I've done before, I'm going to share my screen and I'll just pull up the handout. So hopefully everyone can see this now. And if you would like a copy of it and haven't already received it, I'm sure we can coordinate that through Adam.
Yes.
So
everyone should have received an email earlier today if you registered before 4:30. And I did also put a link, I believe, in the chat. So anyone could download it right now if they wanted to.
Excellent. So sometimes I do fall off on scrolling down. So Adam, I'll rely on you to let me know when that happens, if and when that happens. But as per usual, for those of you who have been with us before, I usually have a lot to say. So I'm going to just dive right in. The cases that we talk about this evening in the land use and zoning context, the vast majority of them are cases that are challenging a determination by a municipal board or official. It's either a property owner challenging an unfavorable determination or a member of the public challenging a favorable determination for another property. So as Adam mentioned, we'll be stopping periodically, and I will be happy to take questions on the case law or the legal precedent that's behind it. And let's get started. The first case is Tampone versus Town of Red Hook Planning Board. So this is just kind of a general introduction case where the neighbors challenged the planning board site plan approval and special permit that were issued to a neighboring property. The court rejected the neighbors' claims that the planning board did not review the statutory criteria required by the code for the site plan review. And the reason for that was that because, and we'll talk about this a little bit more later, as many of you likely know, prior to any determination being made on an application, you have to do SECRA, an environmental review, unless the project is exempt from SECRA. So in this case, while the planning board may not have looked at specific site plan issues at the site plan stage, those issues had already been addressed as part of the SECRA stage. And that there's generally a lot of overlap, such as the adequacy of water supply and sewage disposal facilities, protecting neighboring properties against noise, glare, unsightliness, and other objectionable features. So those are items that are part of site plan review, but were also originally reviewed during SECRA. So the court found that that was sufficient to satisfy the requirements. And that's what's also unique and important about this case is to point out that the specific requirements for site plan review may be specific to each of your zoning codes. So depending upon the municipality you're in, it may identify certain additional specific items that might not be the case. So there may be more overlap or less overlap with SECRA depending upon what your code provides. In this case, the court also upheld the planning board's issuance of a special permit. The court explains that if the code permits a use by special permit, that means the use has already been determined to be in harmony with the general zoning plan and will not adversely affect the neighborhood. That being said, the court acknowledged that if there are certain conditions or requirements set forth in the code on the special permit use, the planning board or zoning board, whatever board has jurisdiction over special permits in that municipality, does not have the authority to waive or modify those conditions. But if the conditions are satisfied, then the permit must be granted because there's already that determination that it's in harmony with the community, subject to compliance with those conditions. And here the planning board had certified that the proposal did comply with the code requirements. And to the extent that the neighbors were claiming that the conditions were not complied with, those were quote unquote mere disagreements with the planning board's determination. But because the planning board's determination was supported by the record, there was no basis to overturn it. The next case is Pepe Porsche of Larchmont versus Planning Board of the Town of Amerenet. So in this case, the petitioner had operated an auto dealership that was permitted by a special permit. So again, a use that had already been legislatively determined to be in harmony with the community as long as it complies with the conditions in the code. And for more than 20 years, the applicant had to obtain a renewal of their special permit every 2 years, which is not incredibly uncommon, though it could be considered a little bit onerous. But with the most recent special permit renewal, the planning board imposed a new condition that had never been placed on the approval before, which was that the petitioner provide proof to the town engineer to establish that the petitioner, which was the tenant of this property, had the right to use an area that was adjacent to the property and was owned by a third party. And petitioner brought an Article 78 proceeding challenging that condition and the town's refusal to accept the landlord's letter affirming that the petitioner could use that property. And the reason why this is a unique case is because the landlord was claiming ownership rights or rights in the property based upon adverse possession, which is generally something that's not dealt with at the planning board or land use board stage. So what the court said was they acknowledge that the boards may impose reasonable conditions and restrictions as are directly related and incidental to the proposed use of the property and aimed at minimizing adverse impacts that may result. So there's no question that the board can put conditions on the approval, but the board cannot put conditions on the approval that are unreasonable or improper. And the court held that's exactly what happened here. The condition was unreasonable and improper, as there was no rational basis to require petitioner to resolve the legal uncertainty regarding the landlord's ability to use the adjacent property as part of the special use permit. And it followed that the town erred in rejecting the landlord's letter verifying the petitioner's use of the property. I was actually a little surprised by this case. The general rule for land use boards is that we don't get involved in resolving private property disputes. That's something that should be done through real property law, real property actions and proceedings law, and goes through the courts. But in this case, it appears that the applicant who operated the auto dealership was trying to use a portion of that neighboring property as their parking lot as part of the use for which they were seeking the special use permit. So it would seem that it was relevant to their use of the property and the application that was before the planning board to confirm that they were able to use that property. But regardless, the court said it was beyond the scope of the planning board. And so it was not a reasonable condition and it should not have been placed on there and it could not be imposed upon the applicant. The next case is Southern Realty and Development LLC versus the town of Hurley. And in this case, petitioner had sought site plan approval to construct a drive-through Dunkin' Donuts franchise. The planning board held several public hearings and meetings with the applicant. And after a year of conducting those meetings and hearings, the application was denied.
Chris, do you want to scroll down?
Oh, yes, thank you. The court noted that while the planning board had failed to set forth its reasoning in a written resolution, the minutes of the meeting where they voted on the application provided an adequate explanation for the court to analyze the basis for the denial. And the reasons that were cited and which the court analyzed in the case were the purported negative impacts on traffic and the maneuverability of large vehicles on the site. So in this case, the court explains that the standard for a site plan determination is that a local zoning board, a local planning board has broad discretion in deciding applications for site plan approvals, and judicial review is limited only to determining whether the board's action was illegal, arbitrary and capricious, or an abuse of discretion. An action is deemed arbitrary and capricious if it is taken without sound basis and reason or regard of the facts. So it's a very deferential standard to land use boards in this context. And in this case, the court rejected the petitioner's argument that the board could not consider traffic impacts as they were listed as relevant factors in the zoning code. So the first issue that the applicant raised was that the planning board shouldn't have even looked at traffic impacts, which to me seems like a foolish argument to make in the first place, because that's one of the basic tenets of site plan, is that you're looking at traffic impacts, circulation, pedestrian throughout the property, and ingress and egress. But then the court went further and did find that there was merit to some to the substance of the petitioner's argument. And that was the substantive rationale of the planning board in denying the application based upon these traffic impacts. And this was a situation where you had, and we see this pretty often, where you have competing experts. So the town planning board had their planner who was raising potential issues with respect to traffic and circulation. And then the applicant had their engineer who was responding to those issues. And so the court found that the basis that the planning board had for denying the application for traffic impacts was not valid, because all of the issues that had been raised had been sufficiently addressed, not only by the applicant's engineer, but also by involving the New York State Department of Transportation, who the applicant had consulted with, and which had agreed to allow the widening of the shoulder on the road in order to allow cars to go by if there was queuing for the cars that were trying to make a left-hand turn into the Dunkin' Donuts facility. The planning board's planner actually rejected this approach, but they didn't really provide any justifiable reason for why it was unacceptable when it was acceptable to the Department of Transportation. The other issue that came up was with respect to stacking capacity of cars on the property. And the petitioner's engineer had presented a study of 2 other Dunkin' Donuts locations in Ulster County, which is where this property was located, with similarly contemplated traffic volumes that found that the longest queue was 14 cars. But the board's planner had determined that a stacking of 21 cars was necessary based upon a very short observation of another location. So even though the applicant disagreed with that, the applicant went back, revised the plans in order to provide that additional 21 car stacking capacity on the property. So it went above and beyond what they thought was necessary, but in order to address the planner and the planning board's comments. They also presented a proposed dual drive-through lanes to increase efficiency. And ultimately, what is unique about this case, in my opinion, is that given the deference that's provided to planning boards when the court is reviewing the case, for a court to look at the case and say, we have competing experts, we have facts on both sides, but what the planning board did was just so out of line that we're going to overturn them anyway. It means that the court took a very hard look, and they felt that there really was not anything for the board to hang their hat on with this one. And the other thing that came into play with this is what was happening at the planning board meetings and what was in the minutes. And it suggested that the planning board may have been influenced by community and local opposition to the project, which is not a basis to deny a project unless there's a legitimate reason behind it. And one of those comments was a suggestion that it would be more preferable to the community to have a, quote, mom and pop shop in the location instead of a Dunkin' Donuts franchise. And the court said these are not valid grounds to deny a site plan application. And so what the court said was, ultimately, while we were mindful, we should not substitute our judgment when assessing the propriety of an administrative determination. Our assessment of the record demonstrates that the traffic-related concerns were adequately addressed by petitioners, and the ensuing reasons relied upon by the board in denying petitioner's application were conclusory and unsupported. So the next case is BMG Monroe 1 LLC versus Village of Monroe Zoning Board of Appeals. So in this case, the petitioner owned 79 acres that spanned the town and the Village of Monroe. They proposed to develop 101 residential units, and the Village Planning Board served as lead agency under SECRA and granted conditional site plan approval in August 2015. The site plan approval was conditioned upon the applicant's compliance with the requirements that were set forth in the SECRA finding statement. We'll talk about SECRA in a little bit. but those are conditions that were placed upon the approval in order to ensure that that any potential impacts, both from the secret perspective and a site plan perspective, were mitigated to the greatest extent possible. And this included the type of siding that could be used, that the roof lines be steeply sloped, and that the architecture adhere to what had been presented to the planning board during the secret process. So 3 years go by, and finally the applicant submits their building permit application plans. And the building inspector denies it because these conditions that had been placed upon the land use approvals were not reflected on the plans that they were proposing to actually build. And so the building inspector denied the application. The administrative remedy is to appeal to the zoning board, which the applicant did, and the zoning board upheld the interpretation. And when they went to court, the court also upheld those determinations as being rational and supported by the record. And this is important to remember because there's a lot of different stages in municipalities in terms of development and land use. So what happens before the zoning board, what happens before the planning board, hopefully in a perfect world translates to the building department when the actual development happens. And the land use boards do have a right to put those conditions on the approvals to make sure that what they're approving is actually compatible with something that can be consistent with the character of the neighborhood and is going to mitigate those impacts to the greatest extent possible.
Christy, if it's all right, I'm just going to jump in. I don't see any questions, but I'm going to give my second attendance verification code word.
Sure.
Again, this is just for attorneys looking for CLE credit. And the second code word is election. As in 2024 will be an election year. God help us. So, not seeing any questions. That's it for me.
Thank you.
Thank you.
So now we're on to area variances. The first case is Nanali versus Zoning Board of Appeals of the Town of New Windsor. So Windsor Hospitality had proposed to construct 2 hotels on its property that was located in the Highway Commercial Zoning District. I'm going to refer to them as Hotel A and Hotel B, which is how they're referred to in the case, but the distinction is important. Hotel A was a 102-room hotel proposed to be 250 feet from the petitioner's property. So this is a neighbor that was challenging these approvals. And they obtained a variance for that building, the Hotel A, for the building height. Hotel B was an 88-room hotel that was proposed to be 1,050 feet from petitioner's property. And this project this hotel needed variances from building height, 1 side yard setback, and 2 side yard setbacks. The zoning board granted the necessary variances. The neighboring property owner, whose property was also in the Highway Commercial District, brought an Article 78 proceeding challenging the approvals. And I'm just going to do a little intro to standing, which I'll talk about more later. But the neighbor had challenged the approvals for both hotels, Hotel A and Hotel B. And the court found that the neighbor actually didn't have standing to challenge Hotel B, because it was proposed to be over 1,000 feet from petitioner's property. And so it was too far to create any alleged injury in fact that would give the petitioner, the neighbor, a right to challenge that. However, because Hotel A was only going to be 250 feet from the neighbor's property, that was close enough to create an alleged injury in fact based upon proximity. And so the board did consider the appeal of the variance for the building height for Hotel A. And so I always like to start my variance cases with one where they give me the standard so that I can convey that to you. And it is the standard that is set forth in state statute, in town law and village law, and in general city law, which is the 5 criteria, which many of you I'm sure know. Whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by the granting of the area variance. Second, whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance. Third, whether the requested area variance is substantial. Fourth, whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district. And 5, whether the alleged difficulty was self-created, which consideration shall be relevant to the decision of the board, but shall not necessarily preclude the granting of the variance. And this is a balancing test. So you have the 5 criteria, but in order to determine whether to approve or deny, you don't either have to accept or reject all 5 of the criteria. And you can, as we'll see in these cases, you can weigh the different criteria more heavily than others based upon the circumstances of those cases. So in this case, the court also noted that, like we talked about with the site plan, with the deferential standard afforded to the planning board, here local zoning boards have broad discretion in considering variance applications, and judicial review is limited to determining whether the action taken by the board was illegal, arbitrary and capricious, or an abuse of discretion. So here the court found that the zoning board did engage in the requisite balancing test and considered the relevant factors in granting the building height variance for Hotel A, and so they upheld the variance grant. The court found that because the properties were all located in a highly commercial zoning district, the variance for the hotels would not change the character of the neighborhood. The zoning board had also considered 3 alternatives to the proposal that they ended up approving, but found that this was the project that minimized community and environmental effects with the fewest variances needed, which is another factor that the boards look at, whether it's the minimum variances that are required for the project. The variance was numerically minimal and its effect was unsubstantial. And while this is important because it'll come up in a future case, while the variance was unquestionably self-created because the proposal was to construct a hotel that did not comply with the height restrictions, the court agreed that in this situation, the factor was not determinative. And another issue that the petitioners, the neighbors, had brought up was that Windsor, the developer, had needed additional variances that were not granted as part of this application. And then they try to use that as a basis to invalidate the variance grant for the project. And the court rejected this because in this type of situation, the zoning board's jurisdiction is appellate only. So the building inspector, the code enforcement official, whoever is designated in the municipality to be the one that determines in the first instance whether a project complies with the zoning, the zoning board then hears the appeal from that determination. So in this case, the building inspector had issued determination saying, you need 4 variances for this project, the 3 for Hotel B and the 1 for Hotel A. And so that was the application that the developer made to the zoning board. And so the zoning board was not in a position as determined by the court to then decide on the spot that the applicant needed additional variances. That would have been something that the building inspector would have had to do. So in a situation like that, if the neighbors felt that the building inspector's denial letter or determination as to the variances needed was incomplete, their remedy would have been to appeal that determination to the zoning board in its appellate capacity in order to assess whether the interpretation of the building inspector was correct. The neighbors didn't do that. Instead, they just tried to argue before the zoning board that the application should not be granted because additional variances were needed, but that wasn't the proper mechanism. And in this situation, by the time these court decisions come down, the time to challenge those determinations by the building inspector, which is generally 60 days, would have long since passed. So the neighbors would have been out of options at that point. The next case is Bonadonna versus Board of Zoning Appeals of Incorporated Village of Upper Brookville. And in this case, the building inspector had issued permits for petitioner to construct piers and fencing that conform to the height requirements of the code. After construction, the petitioner sought final approval from the building inspector, but the building inspector denied the final approval's certificate of occupancy because the construction exceeded the height restrictions in the code. So petitioner then went to the zoning board seeking variances for the height of the fences, 9 piers and 4 entry piers. So this was a lot of work that had been done, none of which complied with the height requirements of the code. The zoning board denied the application and petitioners brought an Article 78 proceeding challenging it. The court found that the zoning board, again, engaged in the requisite balancing test and that its determination had a rational basis and was supported by the record.
Excuse me, Christy, if you could scroll up again, please.
With respect to the first criteria, the character of the neighborhood, petitioner did present evidence that there were other nearby properties with similar conditions. However, the petitioner did not present evidence as to whether those were conditions that had been granted variances or whether they were legal non-conforming, meaning they had been there before the zoning restrictions on the height were put in place. And so without that distinction, the court found that it was appropriate for the zoning board to consider the negative precedent that could be set by granting a variance in that situation without knowing if those variances had been granted in the past. And I know it's kind of counterintuitive. How would the zoning board not know if they granted variances? But in situations like this, the burden is on the applicant to demonstrate that. And so the zoning board isn't required necessarily to go back through its history and its approvals to figure out what it's approved in the past. Obviously, as many of you know as well, zoning board members, planning board members change over time. So some people may be on the board for many, many years and have a lot of institutional knowledge. Others may not. So the onus is generally on the applicant to make that demonstration. And here, because they couldn't make that important distinction, which was important to the court, as to whether the other properties that had piers and decks and fencing that exceeded the height, whether they were legal non-conforming or whether they had been granted variances, the zoning board was able to interpret that in the way it sought to, which was if they granted a variance in this situation, it would be a negative precedent going forward for other potential applicants. The court also acknowledged that the zoning board weighed very heavily on the self-created hardship point. And that's in distinction to the prior case where the applicant went in advance for the hotels. They presented potential options to the board. They worked with the board to try to figure out the best way to get the project done, and they got their approvals. Here, this was a classic example of asking for forgiveness instead of permission. And it can put boards in very challenging situations because, you know, you're members of the community, you're homeowners as well. And so you may be sympathetic to someone who spent a lot of money on decks and docks and fences that don't necessarily, that don't comply. And we don't know why that is. You know, they may have said, oh, we didn't realize it, or our contractor screwed up, or, you know, or we just didn't care. But under these circumstances, the board was upheld by the court in denying these variances, which ultimately meant that the applicant had to remove all of these improvements that had likely cost a substantial sum of money. So that is something that the boards do have the power to do if you can justify it under the criteria for an area variance, which in this case they were able to do with a very heavy focus on the fact that it was self-created. So the next case is Foster versus DeChance. And in this case, petitioners had owned a 9,500 square foot parcel since the 1950s, before there were any zoning regulations on the property. In the 1980s, the property was rezoned to make the minimum lot size 40,000 square feet, essentially 1 acre zoning, thus rendering the property substantially undersized. In 2017, petitioner applied to the zoning board for variances from lot area, frontage, and front side and rear yard setbacks to develop the property with a single family home. So basically, it wasn't going to comply in any way to the current zoning because it was a parcel that was 1/4 of the size that it should have been. Not necessarily because of anything the owners did. They had just owned the property and the zoning had changed. Despite that fact, the zoning board denied the area variances for a single family home, and the court upheld that. The court agreed that the variances were substantial and that there was evidence that the development of the parcel wouldn't conform to the established pattern of development, and that granting of the variances would produce an undesirable change in the character of the neighborhood. And again, like the prior case, the court noted that because no similar area variances had been granted, it could set a dangerous precedent going forward. What the court did not address in this case was whether the hardship was self-created. or whether there were feasible alternatives for the applicant to pursue. Likely because in this case, those factors would have weighed in favor of granting the variances. But the court explained, the zoning board, in applying the balancing test, is not required to justify its determination with supporting evidence for each of the 5 statutory factors, as long as its determination balancing the relevant considerations is rational. So in this case, even though the argument really couldn't be made that the hardship was self-created or that there were feasible alternatives, because the other 3 factors weighed in favor of denial and the zoning board was able to justify that based upon the record, the court upheld it. It's one of those cases that it's a tough outcome for the property owner. You know, they didn't do anything wrong like with the prior case. They just had this vacant lot. The zoning got changed over the years and they wanted to develop it with a single family home. So really, I think their only option would be to try to propose a smaller house where maybe you don't need the extensive amount of setback variances, but given the size of the parcel and the minimum lot size of the zoning, it's unlikely they would have been able to develop out anything on that property without pretty significant setback variances. And then the next case, which is similar in theme, White Birch Circle Realty Corp versus DeChance. In this case, same municipality, petitioner owned a vacant, undersized lot and sought area variances from lot area, frontage, and front, rear, and side yard setbacks to construct a single family home. Again, the zoning board denied the application. And again, the court upheld the zoning board's approval. But in this case, the analysis was different. While the court acknowledged that there were other lots nearby that were similar in size to the property, those lots were created due to environmental constraints such as wetlands, steep slopes, etc., that didn't exist on petitioner's property. In addition, these variances were unequivocally very substantial, 80% for lot area and 54% for lot frontage. And unlike the last case where the court didn't address feasible alternatives, here the court noted that the petitioner did have feasible alternatives in purchasing adjacent vacant lots to make his lot larger, which would have increased the setbacks that they would be able to provide on their lot. Whether that's actually a feasible alternative, the facts of the case don't really lay that out in specific detail, but it is for a court to say, you know, it's an alternative for you to buy another property is a considerable statement to make, and something that probably isn't viable for a lot of people. So that it's another challenging situation where people just kind of get stuck with a property and then they have to try to figure out what to do with it. So the next is use variances. We only have one case on this one. Source Renewables LLC versus Town of Cortlandville Zoning Board of Appeals. In this case, we had a property owner, Gunzenhauser, that owned 38 acres of property in the city of Cortland and in the town of Cortlandville since 1963. Due to environmental conditions on the property, elevations, steep slopes, shallow bedrock, the property could not be developed for residential purposes, which would have been the only thing consistent with the zoning district in which the property was located. The property had been on the market for 30 years. Finally, Gunzenhauser found a potential buyer, Source Renewables, who's the petitioner in this action proceeding. But the sale was contingent upon Source Renewables obtaining approvals to construct a solar energy system on the property. Source Renewables, as contract vendee, made an application to the town with the owner's authorization, seeking a use variance and a special use permit. The IDA, Industrial Development Agency, actually served as lead agency for a coordinated review and issued a negative declaration determining there would be no significant adverse environmental impacts under SECRA. And then because the property was located in both the city of Cortland and the town of Cortlandville, the city of Cortland zoning board had to grant a use variance as well for the portion of the property which was in its jurisdiction, which it did. So the IDA issued a negative declaration determining no adverse environmental impacts. The city of Cortland zoning board issued a use variance for the portion of the property in their jurisdiction to operate as a solar energy system. And then the application came before the town of Cortlandville zoning board for a use variance. And I wouldn't be talking about this case unless this zoning board denied it, which is exactly what happened. So then obviously the owner and Source Renewables go to court to challenge the denial. And before I get to the ending, just to briefly review the standard for use variance, which the criteria is different than an area variance, but the analysis is also different, because for a use variance, you have to satisfy all of the criteria. It's not a balancing test like with an area variance. So for a use variance, you have to prove unnecessary hardship from the zoning regulations, and you have to demonstrate all of the following. First, the property cannot provide a reasonable return as currently zoned, which means demonstrating through dollars and cents proof that they cannot get a reasonable return, not the highest return, not the best return, just a reasonable return from any of the other uses permitted in the zoning district, not just the use that they want to use it for, or that they have been using it for. Second, the hardship results from characteristics unique to the property. Third, the proposed use will not alter the essential character of the neighborhood. And fourth, the hardship has not been self-created. So in a use variance analysis, generally applicants don't get past the first criterion, which is proving that they can't earn a reasonable rate of return through dollars and cents proof. Here, the zoning board said, no, we actually think you did satisfy this criterion by presenting an economic viability analysis from an appraiser that explained why this was the only viable use for the property, given the constraints on the site from an environmental perspective. But then the zoning board found that the applicant actually failed to satisfy the other three factors, and on that basis denied the use variance application. And in a very unique case, because granting a use variance is hard, and given the deference afforded to zoning boards in this situation, it was very unique to me to see that the court actually disagreed with the zoning board in its entire analysis on those last three criterion, and determined that the use variance should have been granted. And that was the directive of the court. So on the second factor, the court found that there was no rational basis for the zoning board to conclude that the hardship was not caused by unique conditions. The zoning board pointed to other houses along the hillside that were similar to petitioner's property that had been developed with houses, but the appraiser's analysis that the zoning board credited in establishing the first factor explained that due to the lack of utilities and infrastructure on petitioner's property, it would cost approximately 4 times more to develop petitioner's property with a home than the other lots. As to the third factor, the court found there was no rational basis for the zoning board to conclude the variance would alter the essential character of the neighborhood. The IDA's coordinated seeker review, which was binding on the zoning board as another involved agency that had discretionary approval authority over the project, concluded that the project would not impair the quality of aesthetic resources or existing community character. The court also noted that any potential visual impacts raised by a member of the ZBA would be the same from the city's side of the parcel, but yet the city zoning board had approved the project, which is also a unique aspect to this project. In this case, if there hadn't been 2 zoning boards considering the use variance application and one hadn't already approved it, if and how might that have influenced the court if there wasn't this other precedent out there for granting the use variance? Obviously, we'll never know, but it was something that the court referenced in the decision. And the final factor, which is also a factor for area variances, but has to be satisfied for a use variance, is whether the hardship was self-created. And in a criticism to the lower court, the appellate court pointed out that the analysis of the self-created hardship was misplaced, because the lower court was looking at the hardship based upon the hardship to the contract vendee who was going to purchase and develop the property. But in this case, what they should have been looking at, what the appellate court said, is you should have been looking at the hardship to the owner of the property, who's owned this property for over 30 years, who's had it on the market for over 30 years, who can't do anything else with this property and is just trying to sell it and make it something productive. And so if you look at whether it's self-created from the perspective of the owner, the appellate court found that it was not self-created, and so it satisfied the criteria for a use variance, and the court determined it should have been granted.
Christy, we have a few questions, so I think I'd like to take this opportunity to give another attendance verification code word, and then we'll get to the questions. The third code word of the night is light, L-I-G-H-T, as in, flip the switch to turn on the light. There's a question that says in Forest versus DeChance, which is the case about the lot that was upzoned and couldn't be put to any use. Did the court address sterilization of the property since it was too undersized to build a house? Was there any other use to which the lot could be put? I'm not sure if sterilization means the same thing as a taking. I mean, that was the thought I had when I heard that case.
Well, it's not really incumbent upon the municipality to take the property or to put it to use if it's private property. But in that case, I believe I mentioned that the court did not address, and the zoning, but presumably the zoning board also did not address whether there were any feasible alternatives to seeking the variances. So I think the analysis in that case was just limited to whether they were entitled to the area variance under the statutory criteria. If they had wanted to do something else with the parcel or, pass it off to the municipality, I think the municipality would have complete deference as to whether or not they even wanted to entertain that.
I mean, my thinking on that is just, the single family home is kind of the, least impactful use there is. And, to deny even that most basic use.
I agree. It's a tough decision. It's hard to wrap your head around. And I try to give you guys as many facts as possible, based upon what the courts give me. But, there's what I see is maybe 3 or 4 pages that's been, dialed down from, hundreds of pages and briefs and analysis and records. So, there may be more to it. But for whatever reason in this municipality, they're not sympathetic to people in this situation, it appears.
Okay. Next question is my area variance question. At what point do combined area variances effectively constitute rezoning? For instance, if in a zone you can build one home on 15,000 square feet and a 2-family home on a 20,000 foot lot, when variances are requested to build a 2-family home on an 11,000 square foot lot is really tantamount to rezoning. Are there cases that address this level of sustainability?
Well, I think that raises a couple of issues because there's also a big difference in zoning between single family and 2-family or multifamily. And I think we might actually get to a case on that in a little bit. So if you're making something a 2-family that very well may not be permitted in the zoning district in which you're located, so that would require a use variance under most circumstances, not an area variance. But to the point about at what point are you actually rezoning the property by allowing variances, area variances that reduce the size of the property? That's a good question, and it's a fact question that unfortunately, that's why these boards exist to look at those issues. I think for a single family, you would probably be hard pressed to have it be argued to be a rezoning. I think it would have to be on a much larger scale than that. But it's certainly something that, having worked with municipal boards for a while, that boards are very cognizant of, because you don't want to be in a position where you're basically creating a precedent that you're changing the zoning or reducing the zoning down below what the legislative board has already made it to be. But again, it's a very fact-specific inquiry. And in these situations that we just talked about, where the property was at one point in time legal, and then due to changes in the zoning, has become non-conforming, I think there's a much more sympathetic argument and justifiable argument for why you would grant the variance, other than someone just wanting to, subdivide and get two parcels out of one, where neither one complies with the zoning. And so that's why the criteria are there, to provide that guidance to the boards. But there's no answer. I can't say, when it's 10,000 square feet over, or when it's 20,000 square feet over. It's all very fact specific, but it's something that boards should certainly consider when they're making these determinations or hearing these applications.
Well, that question kind of reminds me that, I mean, one of the criteria for area variances is whether it's, a significant change to the character. I'm sorry, I don't have them all the terms memorized like you do. It just strikes me that can sort of become a moving target over time, where when variances start getting granted, it's a kind of a snowball effect as to what is considered appropriate for the neighborhood.
Well, that's why, to that point, and this is an ongoing theme in pretty much all of the whenever I do these updates, is make your record for members of the board. Make your record, justify your reasoning, right? Because if you feel like there's one situation that may warrant granting the variance, you want to make sure that you're not creating that snowball effect, where it's going to then the next person's going to come in and say, well, you did it for XYZ, so now you should do it for me. And that's why having very detailed resolutions, and having very and enumerating your rationale is very much to the benefit of the boards, because then because it's very unlikely you're going to get the exact same situation again. And so if you can distinguish either for granting or denying why in that specific situation it was appropriate, in all likelihood, you're going to be able to distinguish it in a subsequent case if it's appropriate. So the more detail, the better, in my opinion.
A couple of people have asked about the attendance verification word, as where you put it. It is only for attorneys. It's not for everyone. It's just attorneys looking for a CLE credit. Please don't repeat it in the chat or the Q&A. It's there to verify people's attendance, to make sure they're here and paying attention, but it is only for attorneys, and attorneys will be putting those words on a form that will be sent out later. And there was one more question here. Well, it's about SECRA. I don't know if we want to wait and hold off until we get to the SECRA section.
Yeah, I'll get to SECRA.
Okay. And one just came in. When there is a case against a zoning board's variance, are the members of the board required to explain themselves and their decision?
Not generally. The general practice would be that it's done through an Article 78 proceeding, which is a summary proceeding that's just done on the record of what was before the zoning board. So the statements that the zoning board members made at the meeting, the resolution that was adopted, or whatever it was, that's certainly all part of the record, and that's supposed to be what explains to the court what the zoning board was thinking and why they did it. There are certain circumstances when that might not be the case. If it's a situation that goes beyond your standard state Article 78 proceeding, such as when we get to the cases later regarding RLUIPA and other federal and constitutional rights. If someone is claiming that those rights have been violated as part of a land use application, then it's possible that the board members could be named individually, or they could be expected, because it's not an Article 78 proceeding, to appear for depositions and defend their actions. But it really depends upon the situation.
Okay. So we'll save that one more question about SECRA. And I'll let you get back to it. I think you might need to scroll up from where you were. Yeah, there you go. All right, thank you.
I'm gonna have to move fast because I have a lot to get through. Okay, so now we're on interpretation and legal nonconforming uses. Basilico versus Southold Town Zoning Board of Appeals. So there were two adjoining lots that were each 20,000 square feet. Lot 1 has single family home, lot 2 is vacant. The properties became non-conforming, which is an issue we've talked about, in 1973 when the minimum lot size was increased to 40,000 square feet. In 1983, so 10 years after the lots became non-conforming, the town adopted a local law known as a merger clause, which you may be familiar with. A lot of municipalities have them. And it basically states that under certain circumstances, if there are two adjoining lots in common ownership, where at least one of the lots is undersized for the zoning district, which in this case, both of them were, then they're deemed merged into one parcel by operation of law. In 1983, when that merger law was adopted, lot 1 was owned by a husband and wife, and lot 2 was owned just by the wife. 17 years later, in 2000, the husband passed away, and as a result, the wife became the sole owner of both undersized parcels, which meant under this law, they were merged by operation of law. Then 7 years later, in 2007, the town adopted another law, amending the merger law to create an exception to the merger clause under the exact circumstances of that case, that situation, if the common ownership is the result of one property owner passing away. So in reliance upon that provision, that there was this exception to the merger clause, the wife sold both of the lots to separate owners in 2017. The new owner of lot 2, which was a vacant lot, sought a building permit to develop it with a single family home. And the building inspector basically said no, because they're merged by operation of law, because this exemption didn't apply to you, because it was merged before the exemption went into effect. So the two new property owners who thought they were buying two separate parcels challenged the determination of the building inspector to the zoning board. Zoning board upheld it, so they went to court. And the court acknowledged that in a proceeding pursuant to CPLR Article 78 to review a determination of a zoning board of appeals, the zoning board's interpretation of its zoning ordinance is entitled to great deference, and judicial review is generally limited to ascertaining whether the action was illegal, arbitrary, and capricious, or an abuse of discretion. However, there is a narrow but very well recognized exception to this rule, that where the question is one of pure legal statutory interpretation, in which case deference to the zoning board is not required. So while the general rule is that the zoning board's interpretation has a considerable deference, here the court said, we're just looking at the terms of this code to see what the rule is. So we don't have to give deference to the zoning board. And with that flexibility, the court said, we don't agree with the zoning board. The exemption was intended to apply retroactively, because it was very clear to the court, maybe not to the zoning board, that it was intended to correct imperfections of the law based upon the town board's actions when they enacted it. So here the court acknowledged that the town board, when it was not clear in adopting the amendment whether it would have retroactive effect, but it was clear that the law was intended to be remedial to correct the unjust consequences of the merger law as it had previously existed by subjecting surviving spouses and other joint owners of property to the loss of the single and separate status of their adjoining properties just because of the death of an owner. So the court basically overruled both the building inspector and the zoning board and said, while it's not necessarily always the standard that laws apply retroactively, and generally it's really not, they only apply going forward unless it's expressly stated. Here, because it was very clear that this exemption was intended to have a remedial effect, that it should apply retroactively, and so that's what the court ruled. So the next case is Mamassi versus Zoning Board of Appeals of the Village of New York Mills. In 2000, petitioner purchased a property that had been used by members of his family since 1944 and was used as a multifamily dwelling. In 1973, the code was amended to limit the property to single-family dwellings. The code allowed the legal non-conforming multifamily dwelling use to continue as long as it was not discontinued for a period of 1 year. And this is a common provision in a lot of zoning codes, that if you have a legal non-conforming, a pre-existing non-conforming use, whether it's a use or dimensionally non-conforming as to bulk requirements, as long as you don't expand the use, you can continue to operate the use as long as it doesn't, as long as the use doesn't stop for a certain period of time. And that amount of time will vary based upon what the code is. It could be 6 months, it could be a year, it could be 18 months. So you just have to be very cognizant of what that is. So in this case, after petitioner acquired the property in 2000, he obtained building permits to make interior renovations and install some decks. After the improvements were complete, though, lo and behold, he had converted it to a four-family dwelling. And so the building inspector would not issue a permit because he said that it was no longer able to be used for multifamily dwelling because that use had lapsed, because it had been for a period not used for multifamily for a period of 1 year. The zoning board upheld that determination, finding that it was actually a two-family dwelling when the code was enacted in 1973 that rendered the use non-conforming. So at most, it could continue to be used for a two-family dwelling. And the zoning board, in the context of the litigation, actually said, we'll let them use it as a two-family dwelling. They just can't use it as a four-family because it was never that extreme. And so basically it would have been accentuating an already non-conforming use to make it more non-conforming, which is almost always not permitted by the code. And the court upheld that, and they said that the zoning board's determination was supported, had a rational basis, and was supported by substantial evidence. The evidence in the record was that in 1973, the property was a two-family dwelling, and that the applicant was not able to present any evidence to the zoning board that the property had ever been a four-family dwelling, and let alone a four-family dwelling, which use had not lapsed for a period of 1 year. And this kind of goes back to what we were talking about before, where the onus is often on the applicant to make that demonstration. It's not up to the zoning board to determine what the use was. If you want to go into a zoning board and say, my use is legal non-conforming, the obligation is on the applicant to demonstrate to the zoning board why they should believe that. And here the applicant couldn't do that. So the court upheld the zoning board's determination that at most it could be a two-family dwelling. And I'm going to skip the Lemon versus Town of Scipio case. It's pretty fact specific, and I don't think it really addresses any legal issues that weren't contemplated in the first two cases. So this is just one quick case on the building department, Hudson versus Town of Orchard Park Zoning Board of Appeals. So the zoning board had granted variances to allow a single-family residential driveway within the setbacks. The neighbor brought an Article 78 proceeding challenging the variance grant, and also a declaratory judgment action, arguing that the driveway encroached upon their property. The neighbor also brought a claim against the building inspector in the nature of mandamus to compel the building inspector to enforce the setback requirements of the zoning code. And this was, so the zoning board had already granted a variance from the setback requirements, and then they brought an action against the building inspector to enforce the zoning code. So there are a lot of backwards things happening here, but I'm raising it for the issue of mandamus, which does come up from time to time. So a claim in the nature of mandamus, which is also brought through Article 78, so it is a summary proceeding, is to compel a municipal official to perform a ministerial act, which is basically an act over which they have no discretion and are required to perform. It's a challenging claim for relief because there aren't a lot of actions that are that ministerial. Often when you see it is the issuance of a building permit or the issuance of a certificate of occupancy, where if you comply with the conditions of the code, there's no discretion for the building inspector to not grant those permits or certificate of occupancy. However, here the court found that a mandamus claim was improper, where they were asking the building inspector to enforce the setback requirements of the zoning code, because the decision to enforce zoning codes rests in the discretion of the public officials charged with enforcement, and is thus not a proper subject for relief in the nature of mandamus. So the applicant was unsuccessful in being able to compel the building inspector to enforce the setback requirements. which, as I mentioned earlier, was also not really a legally viable option because the zoning board had already granted the variances from the setbacks. So at that point, it's beyond the building inspector because the zoning board's already essentially modified the setback requirements for that property. Okay, last one is zoning, and this is two cases, which I'm going to do together, but this is actually a pretty interesting series of facts, and addresses some issues that don't come up very often. So Town of Beekman versus Town Board of Town of Unionville, and Town of Unionville versus Town of Beekman. So I think you know who the parties are. So the Town of Unionville owned a park that was located in the neighboring town of Beekman. So the Unionville owned a park, but it was not within their municipal limits. It was within the municipal limits of Beekman, but still owned by Unionville. Unionville wanted to lease a portion of the park to construct a cell tower, 150-foot monopole cell tower. But as the parcel was located in the town of Beekman, by default, the project would be subject to Beekman zoning regulations. Under the Court of Appeals decision, County of Monroe, there are situations where a municipal parcel can be exempt from zoning regulations on another municipality where the property is located. The Unionville Town Board issued a determination that under the Monroe criteria, which is a balancing of public interest test, the project was exempt from Beekman zoning. Naturally, the Beekman then challenged that determination and it ended up in court. And the court agreed with Unionville and addressed the applicable criteria under County of Monroe and determined that the record supported that the installation of the tower would serve a public interest by remedying a gap in cellular coverage and aiding emergency services, which could use the tower at no charge. The fact that the private interests of the lessee who would be developing and operating the cell tower would also be benefited, didn't undermine this analysis. So basically, the court agreed that because of the nature of what the town of Unionville was seeking to do on this property, they could do it without having to comply with Beekman zoning regulations. But litigation takes a while, especially when you appeal. So Unionville decided to go another route while they were waiting for a determination on their zoning litigation. And so what they tried to do was to annex this property, to have it taken out of the jurisdictional limits of Beekman and put back, well, not put back, but put within the town of Unionville, which owns the property and within its jurisdictional limits. Then it wouldn't have this issue of whether it was bound by Beekman zoning because it would be within Unionville, and obviously Unionville wouldn't apply its own zoning to the property if it didn't want to, and it would have more discretion and it wouldn't have to answer to Beekman. And the court heard this decision, heard this argument, heard this case, and issued both of these decisions on the same day. And the court acknowledged that General Municipal Law 712 does permit a municipality to seek annexation of property, but to do so, the municipality must demonstrate that annexation is in the overall public interest. So we're dealing with two different situations here. The first one is whether the project is exempt from another municipality's zoning under County of Monroe, in which you're looking basically at whether it would serve the public interest. But here for annexation, it's a more stringent standard in whether you have to demonstrate that it is in the overall public interest to have this property annexed from another municipality. And here the court said, no, we don't agree that there's a basis to have this property annexed because Unionville failed to show that unifying government of the park would benefit the public or provide significant public safety benefits, nor did Unionville demonstrate the annexation was necessary to resolve a taxation dispute. The court also noted that generally annexation was not the appropriate remedy for the issue that was being litigated here, and that the appropriate avenue was what Unionville and Beekman were seeking in terms of the zoning litigation, which was resolved concurrently with this decision regarding annexation.
Excuse me, Christy, I'm just wondering, did the Federal Wireless Communications shot clock enter into any of this?
That was not brought up in this case.
Okay, just wondering.
Yeah, no, that was, otherwise I would have put it in the telecommunications section. Yeah, no, it was, I don't know if they just, I think it was it's possibly because it was, before you even get to the shot clock, you have to know what zoning actually applies. So
Mhm.
that, but, and so, Unionville was trying to avoid any sort of zoning regulations, but until that issue was resolved, I guess they really didn't know what they were dealing with in terms of litigation, because maybe if they had gone through the process and had gone to Beekman under the grounds of, a Telecommunications Act application, to your point, they may have ended up better off because of the deference that's afforded to applicants under those circumstances. But it seems like Unionville was pretty adamant about not being bound by their zoning, and that may have ended up working to their detriment in the time it took to get this resolved.
Interesting. Thank you.
Okay, threshold issues. So this is basically what gets a petitioner or plaintiff in the door. If you can't satisfy these criteria, then the court's not going to consider your case on the merits. So the first case, Boyajian versus Village of Ardsley Zoning Board of Appeals. So Thorpe owned a property in Ardsley that its former tenant had used as a gas station until February of 2016, when it removed the gas tanks and equipment and vacated the property. In March of 2016, the landlord then leased the property to a new tenant, Thornwood, to use as a gas station and convenience store. So this is only a difference of 1 month. But then in September of 2017, 18 months later, Thornwood, the new tenant, filed an interpretation to the zoning board seeking a determination as to whether the legal non-conforming gas station use had been abandoned under the zoning code. The zoning board determined the gas station use had not been abandoned, which this case doesn't actually address the merits because it deals with these threshold issues. But that was very interesting to me, because given what the code says about lapsing of non-conforming uses, it seemed like it would have lapsed, and that it would have had to be a conforming use. Notwithstanding such, the issue that was raised before the court was whether it was ripe for review. And so the standard for ripeness is for a challenge to administrative action to be ripe, the administrative action sought to be reviewed must be final, and the anticipated harm caused by the action must be direct and immediate. So there are 2 requirements for a case to be ripe. First is completeness or finality of the determination, and the second is exhaustion of administrative remedies, which I'll get to in a few minutes. So the determination has to inflict an actual concrete injury, and that injury may not be ameliorated through further administrative action. So often we see these types of ripeness issues where if it does to a certain extent go hand in hand with exhaustion of administrative remedies, where if the municipality hasn't made a final determination on their position on an issue, or if there's another board that you could go to in order to get the relief before going to court, then it's generally going to be found to not be ripe for review. So the lower court had actually found that this case was not ripe, and the appellate court disagreed and said it was ripe for review. So the court found that even though the actual land use application for the gas station was still before the Board of Trustees, so that they hadn't gotten their approvals yet. They were still going to the Board of Trustees in order to get site plan approval. In some municipalities, the legislative board does grant site plan approval. So in this case, they didn't have a building permit. They weren't developing yet, but whatever was being determined or reviewed before the Board of Trustees in the context of site plan had nothing to do with this separate issue that had already been determined by the zoning board, which was that the legal non-conforming use had not lapsed. And in none of these other land use board determinations that could come in furtherance of the applicant for pursuing this application, that was not going to be addressed any further. So once the zoning board made the determination that the legal non-conforming use has not lapsed, there was nowhere else for the neighbor who was challenging this determination to go other than to court. And that's basically what made it right for judicial review. But then once the court got past the ripeness issue and said, yes, it is right for judicial review, then they said, but you don't have standing to challenge it. So we're going to throw this out on procedural grounds anyway, and we're not going to consider it on the merits. So the court never actually addressed this issue, and ended up, after all of that time of arguing over whether it was right, the neighbor who was trying to challenge that determination ultimately got told that they didn't have the requisite injury in fact that was intended to be protected by the zoning code in order to challenge that determination. And it's unfortunate that the court didn't address the merits, because in the Ardsley Code, the use, legal non-conforming use ceases after 6 months. So I'm not sure what the basis was for the zoning board to say after 18 months, the use hadn't lapsed. And so that would have been interesting, but it never got to that point. And at this point, it never will. So we'll never know. Next case is mootness, ENP Associates LP versus City of Ithaca Zoning Board of Zoning Appeals. The petitioner challenged 3 different zoning board approvals for the construction of an apartment building on a neighboring property. Petitioner also brought an action claiming that he had the right of access over the neighboring property that had been blocked off for the apartment's construction. The apartment owner argued that all of the appeals are moot because the apartment building has been substantially constructed. So the court explained that the doctrine of mootness may be invoked where a change in circumstances prevents a court from rendering a decision that would effectively determine an actual controversy. And basically what that just means is the change in circumstances is this building being constructed. So it's one thing for a court to say, no, we don't agree with this decision when it's just in theory. But then once there's an entirely new building here, the circumstances change, and the appropriateness of the court to say, you know, we still disagree with this decision and we want you to tear it down. There's a lot more significance, obviously, and it's much more impactful at that point when that's happened. But so when the court thinks about those situations, they also think about what did the petitioner do to try to maintain the status quo to prevent the building from being constructed while this litigation was pending. They look at what did the developer do? Did they get the appropriate approvals? Did they get the permits that they needed? Were they trying to do a fly-by-night type of thing where they were just trying to get the building built as fast as possible so that they could avoid any potential claims that the approvals weren't valid? And so that was what the court looked at in this case. And the court basically said that for all the challenges that the neighbor had brought to this development, I think there were 4 litigations in total. They made only one effort to try to maintain the status quo and to get injunctive relief in order to stop the building from being constructed. They were unsuccessful. But basically what the courts want to see is in every litigation and at every stage of the litigation, that you've made an effort to at least put the developer on notice that you're trying to stop them from doing this, so that they can't then claim that we didn't know, or we have an extreme hardship now. So the court found that just trying at one stage of one litigation and not trying to get a stay once all of these cases were before the appellate division was sorely insufficient. And so the court determined that it was moot. The applicant had done everything the right way. The development was out in the open. The neighbor could see it. They got all their permits and approvals, and it would be such an extreme hardship to the developer and the residents, because now at this point, this was a fully occupied apartment building that it had to be rendered moot under those circumstances, because there was no justifiable basis to even consider the merits of the claim, given everything that had transpired since the approvals were granted. Exhaustion of administrative remedies, Ferris versus Grass. So petitioners filed a building permit application to do construction work on the property. While the permit application was still pending, petitioners commenced construction, which you're not supposed to do, and then they received a violation. Petitioners objected to the requirements for the building permit, claiming they were too onerous. And in that situation, they were advised by the building inspector that they could appeal her determination to the zoning board. But instead of going to the zoning board, petitioners went straight to court, seeking to vacate the violation and getting a judgment directing the municipality to expedite and grant the building permit that they were looking for. So the court explained that for exhaustion of administrative remedies, it is well settled that one who objects to the act of an administrative agency must exhaust available administrative remedies before being permitted to litigate in a court of law. Here, the applicant should have gone to the zoning board first when they were aggrieved, or they had any concerns about the what was issued to the by the building inspector in terms of the violation or the requirements for the building permit. Their remedy was to go to the zoning board. They didn't do so. And doing so, the zoning board could have resolved this dispute without having to go to court. And so by failing to do so, they exhausted their administrative remedies. They failed to exhaust their administrative remedies. And so there was, the court was not going to entertain the substance of the applicant's concerns about the building permit process. The other issue with this is that by the time you get these decisions, years later, by the time it goes through the system, before the Supreme Court, and then you're before the appellate division, the general time frame to appeal a determination issued by the building inspector to the zoning board is 60 days. So by the time these decisions come down, you're long past that time period. So then you're completely out of options. Which does kind of flow into the next topic, which is statute of limitations. So there, in that case, it was exhaustion of administrative remedies has its own basis for how long you have to challenge a determination to the zoning board. So that's somewhat like a statute of limitations, but it also, when you want to challenge the final exhaustion of administrative remedies, often the zoning board or the planning board, to the court, there's another statute of limitations that applies there. So in Fox versus Planning Board of Incorporated Village of Plandome, the planning board granted preliminary subdivision approval on October 22nd, 2020. And the minutes of that meeting were filed with the village clerk on October 30th, 2020, so 8 days later. On January 27th, 2021, so about 3 months after that, the neighbors brought an Article 78 proceeding challenging the subdivision approval. Under state village law, which is the same with town law and also general city law, a proceeding pursuant to Article 78 to review a planning board decision must be brought within 30 days of filing the decision with the village clerk. Here, the minutes that contain the decision were filed with the clerk on October 30th, but the proceeding was not commenced until January 27th of the following year, which was much more than 30 days that's permitted by law. And the statute of limitations is not something that can be waived. There's no deference, there's no sympathy when it comes to statute of limitations. Either you comply with it or you don't. And here, the neighbors did raise some sympathetic issues. They claimed that they were misled or affected by an ambiguity regarding when the statute of limitations started, because that's not always perfectly clear. In this case, the court said it started when those meeting minutes were filed on October 30th, but the neighbors, apparently, they claimed they had been told that that there was going to be a written decision by the planning board memorializing that determination. They apparently had also submitted a Freedom of Information law request where they were seeking additional documents, but they didn't specifically ask for the meeting minutes. So it's an unfortunate situation because they didn't realize what had happened and what their time frame was up against. And by the time you do, it's often too late. So what I like to do, well, I don't like to do it, but when it comes to statute of limitations, when you're challenging a land use determination, is go with the most conservative date, go with the earliest date. And often that's the night of the meeting when it happens, because then you can't be stuck in a bad situation. But otherwise, you know, there a lot of stuff happens with municipalities behind the scenes, and you may not be aware of it until it's too late with the statute of limitations. And on the other side, you know, for municipalities, there's a reason why they get this deference, because they're trying to because you want this repose for municipalities that the issue has been resolved. And so statute of limitations is a position of strength for municipalities when you do end up in these situations, if you're being challenged on a land use determination. Okay, standing. Talked a little bit about this as we've been going along. 1160 Mamaroneck Avenue Court versus City of White Plains. Petitioners owned a legal non-conforming nursery in a residential zoning district. And as part of that nursery use, the petitioner engaged in processing, grinding, and composting of raw materials. In 2016, the City Council considered a local law to prohibit those types of activities, the processing, grinding, composting, as part of the nursery use in residential districts. The zoning regulation was intended to apply to all residential districts in the city, which is a very large area, which made it a type 1 action under SECRA, which we'll talk about in a little bit. Ultimately, the City Council issued a negative declaration under SECRA and adopted the local law. Petitioner commenced the litigation, the property owner of the nursery, because now a lot of what he had been building and operating his business under was now illegal. So it's obviously very harmful to his business operation. So he commenced this proceeding to challenge the adoption of the SECRA negative declaration and also the local law. And so the first issue that the municipality, the city that challenged him on, was whether he had standing. And standing is a threshold issue, and it is petitioner's burden to establish he has standing to bring the challenge. So the petitioner challenged under two issues. There was SECRA and there was the local law. So to establish standing under SECRA, the petitioner has to show an environmental injury that is in some way different from that of the public at large, and that the alleged injury falls within the zone of interest sought to be protected or promoted under SECRA. In this case, the crux of the petitioner's argument that what related to standing was economic harm from the harm his business would suffer from no longer being able to perform those activities. And because those economic harms are not something within the zone of interest sought to be protected by the SECRA environmental regulations, he was not able to establish standing to challenge the SECRA determination. The court did, however, find that he had standing to challenge the actual zoning local law itself. But in that situation, it was a much more stringent standard, because legislative enactments like zoning laws, and this is a quote, enjoy a strong presumption of constitutionality, and parties challenging a duly acted statute face the initial burden of demonstrating the statute's invalidity beyond a reasonable doubt. So that's a very high standard. That's a criminal law standard. So you're as much deference as boards or land use boards are already afforded. Legislative enactments are afforded an even greater amount of deference. So the applicant, the property owner, was not able to challenge the substance of the SECRA determination, was able to challenge the substance of the local law, but the standard to prove to invalidate a local law is so extreme that it was really a lose-lose situation for him just walking into it. Especially because municipalities are authorized to enact land use restrictions or controls that enhance the quality of life by preserving the character and desirable aesthetic features of the community. Here, the court found the council was justified in its actions because these activities were harmful. No one doubts that. I'm sure in a residential district, you don't want people grinding or processing or composting. But on the other hand, this person who had been using this property and operating his business there for years was all of a sudden unable to continue to do so. So that was just an interesting situation. And what I like about that case is that it demonstrates how you can have standing for one issue, but not another, because it all relates back to what the zone of interest is of what the law is intended to protect. And so zoning laws are different in that respect than the seeker regulations. So the next case is Ateris Beis Yaakov Academy of Rockland versus Town of Clarkstown. Adam,
Can I just jump in with another code word, because it's been a little while since the last one. The fourth attorney attendance affirmation code word is calendar. Now is a good time to order your calendars for next year. So, and there are a couple of questions, but they're both dealing with SECRA, so I think we'll wait till we get through the SECRA cases before I share them.
Okay, sounds good.
Thanks.
Okay, so Ateris Beis Yaakov Academy of Rockland versus Town of Clarkstown. So the petitioner is a New York State chartered educational corporation that was providing secular and religious instruction. Petitioner entered into a contract to purchase property to use as a house of worship and a school. The building inspector denied a building permit to make repairs because the use required several variances. Petitioner appealed the determination to the zoning board that they needed variances and alternatively sought the variances from the zoning board, which isn't uncommon. If an applicant isn't satisfied with the building inspector's determination, you can appeal the determination. And then if the zoning board doesn't grant you the appeal, then alternatively, you can seek the variances that were determined to be needed. But it basically gives you two shots at getting the relief you're requesting, and the board may be more amenable to giving you one of those options for relief. So that was what they did here. But while the petitioner sought to continue to pursue the applications before the zoning board no longer would entertain them because petitioner had not closed on the property, and as a result, the property owner had terminated and revoked the petitioner's authorization to seek the land use approvals. So once the petitioner no longer had the authority to seek the land use approvals for the property, the zoning board stopped considering the application, rightfully so. So petitioner then went to court to compel the zoning board to hear the application and to annul the building inspector's denial of the building permit. The court acknowledged that while generally immediate parties to an administrative proceeding are aggrieved parties who have standing to seek a judicial review, which in this case, the immediate party would be the petitioner who had made the application to the zoning board. In this case, because of the termination of the contract of sale, petitioner lost its interest in the property and the land use applications. Therefore, petitioner lacked standing as an immediate party. Petitioner also couldn't establish the traditional requirements for standing, as it didn't suffer an injury in fact within the zone of interest sought to be protected by the zoning regulations. Petitioner claimed that it was harmed by the denial of the building permit and the delay in hearing the application, which caused it to lose financing and the contract being terminated. Even accepting this as true, the court found the loss of the contract was not within the zone of interest of the zoning provisions that are enacted to protect the health, safety, and welfare of the community. So ultimately, the court found that the applicant didn't have standing and could not pursue the litigation against the town. And I'm going to shortage of time, so I'm going to skip over the last case, the Creta LLC versus City of Kingston Planning Board. It's similar to the other standing cases regarding SECRA and its carryover from the spring. So in the interest of time, I'm just going to skip that one. And we'll move on to secret, which I understand is there's some interest on. So the first case is Andes versus Planning Board of the Town of Riverhead. The planning board approved a subdivision application after determining the application constituted a type 2 action that required no further environmental review. So the court explained that judicial review of an agency determination under SECRA is limited to determining whether the challenge determination was made in violation of lawful procedure, was affected by an error of law, or was arbitrary and capricious and an abuse of discretion. Review in courts must review the record to determine whether the agency identified the relevant areas of environmental concern, took a hard look at them, and made a reasoned elaboration of the basis for its determination. So again, we're looking at a deferential standard to land use boards in making a secret determination, but here the board has to identify the areas of environmental concern and make sure that they take a hard look at them and explain how they're resolving that in a reasoned elaboration. The other key element of secret, which we've talked about a little bit earlier, is that a secret determination has to be made before you can take any action on any of the other applications. So the first step is to determine what type of project it is. Is it a type 1 action? Is it a type 2 action? Or is it unlisted action? So for a type 2 action, those are actions that the DEC has already determined are not going to have a significant adverse environmental impact, and so they do not require any further secret review. Type 1 actions are actions that are presumed to have the potential for at least one significant adverse environmental impact, and those do require further secret review. Unlisted actions are everything else in between and also require secret review. So in this case, the planning board had determined that a type 2 action, that the subdivision application was a type 2 action and did not require any further secret review, which was not correct. A type 2 act, there's nothing in the DEC's type 2 list that states that subdivisions of any kind are exempt from secret review. And so that typing it as a type 2 action exempted it from environmental review that should have been conducted on this project. The planning board tried to argue that it was a type 2 action under the local zoning regulations. And so this is something that local municipalities can do, and it is authorized by the DEC regulations, is that municipalities can create their own type 2 list of exempt actions and can create their own list of type 1 actions, which require additional environmental review. You can't mix and match them. So you can't take something from a type 2 list and put it on type 1 or vice versa. But in this case, the municipality, the legislative board, had actually amended the code to include minor subdivisions, which would include this application as a type 2 action. However, they didn't do that until after the planning board had already made the secret determination. And therefore, the planning board could not rely upon that. So because the type of the action was wrong, and as a result of the type of the action being wrong, the adequate environmental review was not conducted, the court found that the board did not take the hard look required substantively under SECRA, and the entire SECRA determination and every approval that followed it was annulled. So the next case is 61 Crown Street LLC versus City of Kingston Common Council. The city had enacted code provisions that permitted residential development in the mixed-use overlay district with a special permit, and required a residential development with 5 or more housing units to have at least 20% of affordable housing. So you had a mixed-use district where residential uses were permitted with a special permit. And in those residential uses, if you had more than 5 units, you had to have 20% affordable. One project came in and the city council decided to amend the code to make the residential uses permitted in the mixed use district as of right, and to also reduce the affordable housing requirement from 20% to 10%. with respect to this application, the city council stated that these were unlisted actions under SECRA, but then said no further environmental review is required. So the issue here is that they were, unlike the other application where it was mistyped, where they said it was a type 2 when it was actually unlisted, here they were correct in saying it was unlisted. But the fact that it's unlisted means that you do have to conduct a secret environmental review. Here, they didn't do that. They said it was unlisted and then didn't conduct any environmental review. And the court basically came to the same resolution that it did in the previous case, that if the misclassification of the typing of the action changed the entire scope of the review, there was no basis for it to be for there to be no environmental review of this if it was an unlisted action. In the litigation, the city actually tried to argue that it was a type 2 action, and they had just mistakenly referred to it as an unlisted action. And the court said, no, there's nowhere that this falls on the type 2 list. This isn't an interpretation of an existing law. You're changing the law. You're saying that a use that was permitted by special permit is now permitted as of right, and that an affordable requirement that was 20% is now 10%. Those are substantive changes, not just interpretations. And so because the environmental review wasn't done, the secret determination had to be invalidated along with all the subsequent approvals that had been issued. So the next case is the two cases, Tampone versus Town of Red Hook Town Board, Tampone of Town of Red Hook Zoning Board of Appeals. So there was a proposed subsurface sewage disposal system proposed on a lot that was split between two zoning districts, residential and commercial.
Could you just scroll down, please, Christy? Sorry. Thank you.
The building inspector determined that the use was permitted as a non-residential accessory use, and petitioners challenged that determination to the zoning board. The zoning board upheld this building inspector's determination, and the petitioners went to court. So while this litigation was pending, the town board, which is the legislative board, saw what was going on and said, you know what, let's make the law clear, because we do intend for this use, this subsurface sewage disposal system, to be a permitted use in these zoning districts. And so they amended the code in order to do that. But because it applied to several zoning districts, if it's over 25 acres, then it's a type 1 action if it's affecting more than that amount of acreage. So in this one is a type 1 action, which carries with it a presumption that it's likely to have a significant adverse impact on the environment that would require preparation of an environmental impact statement. But even though there's this presumption that it will require an environmental impact statement, the EIS, environmental impact statement, is only actually required if the determination is made that there is the potential for at least one significant adverse environmental impact. Just the presumption is not enough to require an EIS. So here the court found that even though it was a type 1 action, the lead agency had identified the relevant areas of environmental concern, had taken a hard look at them, and made a reasoned elaboration for the basis of its determination to issue the negative declaration, finding the project will not have any adverse impacts. And therefore, even though it was type 1 action, an EIS was not required. In addition, the petitioners had also challenged the zoning amendments on the grounds that it was impermissible spot zoning. And this is something that comes up every now and then. So that's why I wanted to address this case. Spot zoning is the singling out of a small parcel of land for a use classification totally different from that of the surrounding area, for the benefit of the owner of such property and to the detriment of the other owners. Here, the court found that because the record showed the law was consistent with the town's comprehensive plan and was calculated to serve the general welfare of the community, it was not spot zoning. And I'm going to skip over the Boise versus City of Plattsburgh case for time purposes. The function of this case, it's very fact specific. But what I wanted to point out on this was that the lead agency conducted a very thorough seeker review and ultimately issued a finding statement, which is supposed to identify the ways to mitigate a project. And so the court was actually asked to look at two specific issues related to that analysis. One was with respect to the effect of aquatic birds, and the other was with respect to the effect of disturbing contaminated soil. And looking at it point by point, the court said that the analysis, the environmental analysis, and the mitigation measures with respect to the aquatic birds was fine. But that analysis with respect to the mitigation measures for the contaminated soil was insufficient. So just for the purposes of secret, I think it's important to know and to keep in mind that it's not just this one bundle of one document, that's, either it's all good or it's all not. The court, especially with secret, will go point by point and analyze every single environmental issue that could potentially have to be addressed, and then determine for each of those issues whether the lead agency sufficiently identified the area of environmental concern, took a hard look at them, and then made a reasoned elaboration for their determination. And so in this case, even though one aspect of it was fine, another aspect wasn't, and so the entire finding statement was annulled.
Like I said before, we do have a couple secret questions I've
Yep.
held off on. Are you aware of anything that relates to the need for secret, i.e. not type 2, for area variances when the number of area variances become numerous and substantial, such that the combined impact is effectively rezoning and a change in community character?
It depends. For area variances, it's based upon the nature of the use. So for single family, 1, 2, and 3 family residential uses, as long as it's an area variance, it doesn't matter how many variances you need or the scope of them. It's a type 2 action.
Okay. And regarding the secret determinations, if no land use decision based on the secret determination, if no land use decision based on a secret determination, what is the timing to challenge a secret neg deck? What if there's a document that is called a neg deck, but no minutes, resolution, or decision reflecting the vote?
That's a good question, because the law is there were no cases on that this time, but the law is a little fuzzy on that one, because the general school of thought has been that a secret determination isn't ripe for review, so to speak, as we discussed that earlier, because it doesn't actually permit you to do something. So if someone issues a neg deck, it doesn't mean you get those approvals. But I'm not going to sit here and say don't challenge a neg deck when it comes out, because like I said, with statute of limitations, you never know, and it's better to be too early and told to come back when a determination is made, rather than be told it's too late, because then you can't come back. So my school of thought is generally be as conservative as possible in your challenges, and if you have to put something over or you have to refile, at least then you can do it and then as far as what the statute of limitations would be for that, it depends upon what the board was, which board it was, and what they were doing. It could be as short as 30 days, it could be 4 months.
Okay, don't see any other questions for secret, so thank you.
Okay. Wireless telecommunications. Selco partnership versus White Deer Township Zoning Hearing Board. So we're in Pennsylvania now. White Deer Township had a gap in the Verizon's wireless coverage on Interstate 80. Verizon sought to fill the gap to prevent dropped calls, and they present it as it could be a hazard for stranded drivers. Pennsylvania had actually enacted a moratorium that prohibited the construction of cell towers on state forest land, which limited Verizon's options as to where they could put the cell tower. So they found a parcel where they were able to lease 2,600 square feet to construct a 195-foot monopole with a 4-foot antenna on top of it. the minimum lot size under the local zoning for a cell tower was 1 acre. So this was at 2,600 square feet. This was, substantially smaller than that, where an acre is about 42,000. So they needed several variances. They had to go to the zoning board, and the zoning board denied them. And so then the Verizon brought a lawsuit claiming that the denial violated the Federal Telecommunications Act, which was intended to reduce regulation and encourage the rapid deployment of new telecommunications technology. And the court went through a very good analysis of the history of the Telecommunications Act and explains that Congress preserved local zoning over the placement, construction, and modification of cell towers, but not if it prohibits or has the effect of prohibiting the provision of personal wireless services. So the court, this is the Third Circuit again in Pennsylvania. The court adopted the Federal Communications Commission standard for review as to what has the effect of prohibiting wireless services. And the inquiry is whether it will prohibit government action. The intention is to prohibit government action that materially limits or inhibits the ability of any competitor or potential competitor to compete in a fair and balanced legal and regulatory environment. And so this is what the court referred to as the materially inhibits standard. And so relying upon the cases that the FCC cited in its guidance, which included a case from the Second Circuit that's controlling in New York, the court was able to extract certain principles for what constitutes the materially inhibits standard. And the first is that a prohibition does not need to be complete or insurmountable in order to run afoul of the Telecommunications Act. Second, the local government action which imposes reasonable fees or costs materially inhibits wireless services. And third, you have to look at the totality of the circumstances when you're considering whether it materially inhibits the operation of the cell tower. Because in one municipality or on one property, it could be a completely reasonable and suitable restriction, but in a different situation, it could be inhibiting. And so you can't, it's very fact specific, like we were talking about earlier with area variances and whatnot, where you have to look at the specific facts of the case to determine whether it applies. And so the court also referenced the FCC's guidance to local municipalities when enacting legal requirements for wireless facilities. And so the guidance is for when you're doing aesthetic requirements for cell towers, the requirements be reasonable, don't be more burdensome than those applied to other types of infrastructure, and be objective and publish it in advance so people know what the restrictions are before they come in. And so based upon this new materially inhibits standard, the court found that the zoning board did violate it. The court noted that Verizon was already limited in where they could put their cell tower because of the moratorium that had been in place by the state. And the zoning board actually argued that, well, Verizon could have just sued the state to get the moratorium removed so that they could then put in a more suitable location. And the court said that went against these new standards because that would substantially increase the time and cost that it would take to get these approvals. If you were going to say to Verizon, okay, well, just go sue the state of Pennsylvania and come back to us in 7 years when you're done, because that's probably how long something like this would take. And what was also important about this decision is that the court made clear that to a certain extent, and this isn't new, but it bears reminding, the Telecommunications Act does preempt local zoning statutes, local zoning regulations, stating local zoning boards can operate to the full extent of their power when regulating the placement of cell towers and the like, as long as their actions do not have the effect of prohibiting personal wireless services. And what's also important is that when we talk about demonstrating the need for personal wireless services, generally in the past, what we've talked about is whether there's a gap in coverage or there's a gap that needs to be filled. Now they're saying it doesn't just apply to insufficiencies in coverage, but also to insufficiencies in local capacity, in network capacity, 5G services, and new technology. Local zoning boards are prohibited from preventing providers from meeting those broader interests. So now we're looking at an even more broad scope of what the deference would be to telecommunications providers in order to be able to accommodate technology as it's constantly evolving and changing, not just what we've thought about in the past with these coverage gaps that need to be filled in, which is how this case originally started. Okay, our LUPA, religious uses, last topic of the night. So I am going to skip the first case, Alive Church of the Nazarene versus Prince William County, Virginia. This is a carryover from the spring update. And it's very lengthy factually, but if anyone has any questions about it, I'd be happy to shoot me an email. I'll be happy to give you any more information that you would like. And so moving on to Catholic Healthcare International Inc. versus Genoa Chartered Township, Michigan. So Catholic Healthcare acquired a donated 40-acre wooded property and installed a prayer trail with 14 stations of the cross. Even though the county park had a 15-station series of large signs that told the story of Leopold, the township considered the stations of the cross to be the prayer trail to be a church that required a special use permit. The church was required to submit a special use permit application, a site plan application, a $3,000 application fee, and signed and sealed engineering plans. Catholic Healthcare conveyed their surprise to the township that the Stations of the Cross were being considered a church that required a special use permit, and ultimately installed the prayer trail anyway, although they could not be viewed by anyone outside of the 40-acre property. Catholic Healthcare then made an application for a special permit for an actual church, a 6,000 square foot chapel, a driveway, parking lot, and the prayer trail. The town denied the application on the grounds that it wasn't consistent with their master plan. So Catholic Healthcare commenced a litigation that the township's zoning ordinance violated our LUPA. So our LUPA is the Religious Land Use and Institutionalized Persons Act. This is a federal law that, like we were just talked about a little bit with telecommunications, also to a certain extent supersedes the zoning regulations at a local level in order to accommodate uses, religious uses that are determined to be inherently beneficial to the community. So Catholic Healthcare commenced this litigation that it violated our LUPA. And there were actually two litigations pending simultaneously. And in state court, the town was able to get an injunction against Catholic Healthcare to remove the prayer trail, which they did. The church then made another application to the town for a second special permit, but this time just for the prayer trail, the driveway and the parking area. So removing the 6,000 square foot chapel. And the township just basically said that there aren't enough substantial differences from the prior application for us to consider this. And so they just kind of said, we're not entertaining it, even though the majority of the basis for the initial denial was based upon the impacts from that 6,000 square foot chapel. So the initial issue was whether the claims were right. And this court had rejected the claims that the argument that the claims were unripe, explaining the standard was the necessary event is simply that the government has adopted a definitive position as to how the regulations at issue apply to the particular land use situation. And in this situation, the municipality had very clearly said, we are requiring you to have a special permit for the chapel, for the prayer trail, and we're not granting it to you. So there was no ambiguity in the court's mind that this was the government, the municipality had made a definitive determination. So after determining that the case was ripe, the court then considered whether the township's actions in treating the prayer trail as a church and requiring a special permit were a substantial burden on their religious exercise. And for a burden to be considered substantial, it must have some degree of severity and be more than an inconvenience. And the court found that Catholic healthcare has indisputably suffered substantial delay, uncertainty, and expense due to the imposed zoning regulations after 2 years of administrative proceedings and being unable to place religious displays on the prayer trail. The township argued that Catholic healthcare brought this burden upon itself because it should have known in advance when it acquired the property, that it would have to obtain these land use approvals in order to have the prayer trail. And the court rejected this argument, saying, based upon the clear language of the code and a rational interpretation of the code, the church had no reason to believe that the municipality was going to consider this prayer trail to be a church or temple, so to speak, that was defined as a structure wherein persons regularly assemble for religious activities. Obviously, if it's a prayer trail and you just have signs and statues places, people can't be in something congregating and assembling for religious instruction. And that was the important distinction that the court made. The court found that it was much more reasonable for Catholic healthcare to believe that this would be treated like a private non-commercial park, a nature reserve, or a recreation area, especially given the fact that a similar type of setup was permitted in the county park with respect to the stations of Leopold. And because Catholic healthcare had demonstrated a likelihood of success on the merits of their substantial burden argument, the burden then shifted to the town to demonstrate that getting the special permit, then it was subject to strict scrutiny under constitutional law. And so the town would have had to demonstrate that getting the special permit was narrowly tailored to advance a compelling interest. And the court said the town didn't even really bother trying to establish that. And then the last case, really quickly, is Satanic Temple versus City of Belle Plaine, Minnesota. So the city had designated Veterans Memorial Park as a limited public forum and granted permits to the Satanic Temple and the Veterans Club to place monuments in the park. So they gave permits to these two presumably very different groups, the Satanic Temple and a Veterans Club. And after the permits were issued to both, the Veterans Club statue was complete, and so they put theirs in the park. And then while the temple's statue was being prepared, I guess there started to be rumblings in the public. They weren't happy about whatever this temple was going to be putting in the park. And so the city said, you know what, we're going to take it all back. We're not just taking it back from the temple. We're going to take it back from the Veterans Club. We're no longer letting any sort of statues or anything be in the parks. Everyone has to take it away. And so the Satanic Temple brought a claim under RLUIPA challenging that it violated their rights. And the court said that, all you really had was a revocable permit to put a statue here. You didn't have any property rights in this park where you could be expected. You had a reasonable expectation to be able to use the land. And that's one of the aspects of RLUIPA that I think kind of gets overlooked sometimes, is that you have to have a reasonable expectation of ownership rights of some sort, whether it's an easement or ownership to use the property. And so if you just have a revocable license that a municipality can just take away from you at any point in time, that doesn't give you the rights in order to be able to assert a claim under RLUIPA. And so that's what the court said with respect to their RLUIPA claim. The court also rejected the constitutional free speech and equal protection claims. With respect to free speech, the court said that there's nothing in the Constitution that requires the government to freely grant access to all who wish to exercise their right to free speech on every type of government property. And the court also made a second mention, as I noted earlier, that they didn't just take the free speech right away from the temple. They took it away from the Veterans Club. They took it away from everyone. So they applied it across the board, which is also what defeated the temple's claim that there was a constitutional violation with respect to equal protection, because they couldn't show a comparator that had been treated any differently, because they had been treated exactly the same as the Veterans Club. The only argument they were able to make was that the Veterans Club had already put their statue up there and had had it there for a few months before it had to be taken down. But the city said, you know, we gave you the permits at the same time. The fact that you guys took a longer period of time to get your statue done, that's not our fault. The Veterans Club just put it up when they were ready, and then we took everything back. So it didn't state a claim. And so the court basically threw out all of their arguments. And I'm sorry I went over by 6 minutes.
All right. Well, yeah, I just wanted to wrap things up very quickly, since I imagine people tend to drop off. We are a little bit over time. There are some questions that we can get to after in a few minutes. I don't mind staying on, but
I have no problem saying.
okay, great. Just want to say thank you very much again, Christy. You know, I think we're all very lucky to have you. And I'm trying to think how many times you've done this. I think you started a little bit before I did, so I'm not sure. I'll have to go back and look. But thank you for keeping it coming back, not just every year, twice a year. And I also just want to say thank you to all the board members out there. Serving on a board is a fairly thankless job. So every once in a while, you deserve to be thanked. So thank you.
Absolutely.
Also, and if you're not on a board, thank you for giving up your time tonight to learn a bit more about your community and the issues that face it. Once again, if you are on a board outside of Rockland County and want a certificate of attendance, please send me an email, which is still available in the chat, or if you have any other questions. But with that, I'll just say good night. And for people who want to stick around for the questions, please do so. We'll take a few more minutes, I think, and cover those questions. But for everyone else, have a good evening.
Bye, everyone. Thank you. Happy holidays.
All right, let's see. Lots of thank yous. Well, actually, the question is just kind of a clarification on the question from before about neg decks and filing. No other decisions for 4 months, but what date, if there are no minutes or decisions or resolutions filed? What triggers filing of neg deck or filing of decision, minutes, or resolution? I don't know if you could. So.
Sorry, I'm just pulling it up. I would say the earliest one. I like I said, I always try to be really conservative with these things. So to say the filing of the neg deck or the filing of decision, minutes, resolution, I would say whatever happened first. That's the most conservative way to be. Because this is one of those situations where I'm kind of in a vacuum right now. I don't know all of the background of it, so I can't really say in what order it happened or what's the definitive action. Sorry, I just realized I'm still sharing my screen. So yeah, statute of limitations is tricky because you also never know what a court's going to decide. So I would say the first is the best.
Yeah. I mean, a saying I've come up with is that everyone agrees what a law says, but when it comes to what a law means, we're all just guessing.
Yeah.
The judges get the later guesses, and
Absolutely.
the Supreme Court gets the final guess. And so actually there's a lot of comments in the question, but basically just saying thank you. Just trying to see if there's a question. I appreciate all the thank yous. Someone who says they've seen you at least 4 times.
Oh, sorry.
Oh, I know you've done much more. You've done more than that. Lots of thank yous, lots of great presentations.
Yeah.
I know people put in,
I would have to look back in my files to find out how far back it goes. I'm sure Steve Silverberg still isn't on, but he might know.
yeah, well, I think you did some with
Oh,
him.
he's still there.
Still on? Okay. Well, I hope people I've are asking, they're putting their emails in the chat. Please send me an email. Send an email to my email account if you want a certificate of attendance. That's how I will know to do it. This chat is going to disappear once we close this session. So I'm not going to stay here and write them out. So please send me an email if you want a certificate of attendance. So yeah, I don't see any other questions other than a few people asking about certificates. So I guess once again, I'll say good night and thank you again. And yeah, we're down to 38 attendees. So I think we could stop recording and call it a night.
Thank you all very much.
Thank you, Christy.
Bye, Adam. Take care.
You too.